All right. Hello, everyone. Thank you for joining us. My name is Zach Ahlstrom. I'm a senior attorney here at Berardi Immigration Law. I'm joined with Ruth Garbanzo of my team, another attorney here at the firm. And today we're going to talk to everyone about the immigration considerations of starting or expanding a business in the United States. Um, Before we get into it, I just want to give like 30 more seconds, let everyone join in. It just hit noon, so we'll give everyone a few more seconds and then we'll dive into the immigration considerations and some of the visa categories that we're going to chat about. All right, so as I mentioned, today we're going to talk about starting or expanding a business in the United States. And there are going to be two primary immigration options that we're going to discuss that are commonly utilized to expand an existing business or start a new business in the United States. The first is going to be the L1 category, commonly referred to as the intracompany transferee visa. This allows companies to not only existing companies with operations already in the U.S. and abroad, it allows them to transfer employees, executives, managers, specialized knowledge employees from that office abroad to the U.S. But maybe a little known fact is that the L1 can also be utilized to open a new office. It enables those same foreign operations to send similar employees to the U.S. to open a new office. There's a lot of benefits to the L1. There are some negatives to the L1, but it is a great visa option for companies, both multinational companies and companies looking to go multinational. The other category we're going to talk about is the E2 Treaty Investor Visa. Now, this is similar to the L1. It can be utilized by both existing and new companies. It can be used to expand your business to establish a new company. It can be used for multinational companies that maybe made an investment in setting up a U.S. subsidiary in the past, and they need to transfer personnel from abroad to the U.S. There are a lot of different ways that the E2 can be utilized, but ultimately, it's another great option with a lot of benefits that's going to support business expansion into the U.S. market. So firstly, we're going to dive into the L1. Ruth, if you can give us a little bit of background about the L1 category, some of the key requirements, when to use this, key considerations, validity period. Just give us a general breakdown of the L1.
Yeah, thanks, Zach. So as Zach kind of already got started mentioning, the L1 visa is designed for multinational companies to transfer talent to the US. There are two main scenarios for this type of visa. One is for existing multinational operations. So if your company already has operations in both the US and abroad, the L1 allows you to transfer executives, managers, or employees with specialized knowledge to the US entity. The second scenario is expanding your operations into the US. So if you do have operations abroad and wish to expand into the US, the L1 can be used to transfer again personnel in an executive, manager, or specialized knowledge capacity to help establish and lead that new US office. So some of the key requirements for the L1 are first, that the petitioning employer, the US entity, must be doing business and have a qualifying relationship with a foreign entity. So this can be in the form of the relationship being as a parent, subsidiary, affiliate, or branch. Second, the employee must have at least 1 year of full-time employment abroad in one of those capacities as an executive, manager, or specialized knowledge employee within the last 3 years. And when they transfer to the US, they will hold a similar role in the US.
And Ruth, just to jump into the requirements here, what is some of the documentation that employers are going to need to present in order to prepare an application to transfer an employee to the United States?
Yeah, so some of the documents that we typically include with these filings, one, we show, incorporation documents, we show tax returns to show financials of the entities doing business. We show payroll summaries to show the employee counts of the foreign or U.S. entity. And some of the documentation, and then of course, evidence of the affiliation. For the employee side, typically what we show is their latest, for example, for Canadians, their latest payroll statement or T2.
The T4 summary, yeah.
T4 summary, yeah. T4 summary. And then we could show 12 months of pay statements. And we also include an org chart showing their role within the foreign entity and, whether they have direct reports, whether, their function manager, how that plays into effect within the entity or the organization. So those are some of the documentations that we typically include within one of these filings.
Yeah, so we have employer requirements and employee requirements. And as Ruth said, the government wants to see that you're doing business abroad and that you're doing business in the United States. So if you're generating revenue by providing goods or services, that's generally the baseline threshold, and we just need evidence to document that. From the employee standpoint, we just need to show that you're executive, managerial, and specialized. That's either that really does depend on the individual circumstances of the case. And there are a lot of creative ways to demonstrate that. Now, that's the requirements for an existing multinational company. That's a company that already has operations in the United States and operations abroad. Ruth, are there special requirements for an organization that's trying to set up a new office in the U.S.?
Yes. So typically for new office applications, we'll want to show, that they already have an FEIN number. So we'll include like an IRS letter that shows their FEIN number. We want to show that they have office space in the U.S. Typically, USCIS and CBP likes to see brick and mortar office space. Additionally, for new office applications, it's really important to include a business plan to show their 5-year financial projections, hiring plans, and growth strategy within that year period and beyond. Because as we'll get into, for new office applications, they only have a validity period initially for one year period.
Yeah, and with the new office cases, the key is the office space. It's in the name. It is outdated. There's a lot of businesses that can function without an office, but that's a consequence of the old immigration law. It hasn't been updated significantly in 40 plus years. So when these cases are adjudicated, officers want to see that you have a lease agreement in place and you have sufficient office space to support your business. Now, generally, most cases, you're going to need some sort of brick and mortar office. But if there is an argument to be made that like a shared office or even a virtual office space is sufficient to support your business operations, you can get away with it. And we have done it successfully with a lot of clients. It truly just comes down to demonstrating that you have space secured and that it's sufficient to support this new organization. So Ruth, can you tell us a little bit about the actual application process, both for Canadians, which is a little different, a little simpler, and for pretty much all other nationalities?
Yeah, absolutely. So for Canadians, they have the benefit of applying directly at the border. And this is great because they can do it right there at a land port of entry, or they can do it at a pre-clearance airport. The benefit of this is they have interaction with CBP, so they can be asked questions on the application, they can answer it, and they'll get an adjudication immediately. Typically, when applying at the border, for example, if you're doing a land port of entry, some ports require scheduling in advance. So typically, you can get those scheduled about a month out. And as I said, right then and there, you'll know immediately the decision of the CBP officer, and you can enter immediately on the L visa. For other nationalities, however, first you'll need to file with USCIS, and then you'll have to apply for a visa abroad at a US consulate. If you're doing the standard processing times, this can take several months, unfortunately. It's very delayed and lengthy. But there is the benefit of premium processing that does require a hefty fee, but it is available, and if done, the case can be adjudicated within 15 business days. So
Yeah, it's not a
it's a nice
decision
option.
on the spot, but it is definitely much quicker than the standard non-premium processing times.
Mhm. Yeah, absolutely. Um, so, yeah, as we mentioned, the most straightforward path is definitely for those Canadians that can apply right there at the border. It's quick, easy, and a great option for them.
Absolutely. And in terms of the validity period, is it different for new office versus you say the non-new office petitions for companies that have existing operations? I think you alluded to this earlier.
Yes, I did. So for new office applications, they're granted a period of 1 year initially, and then they can renew. The idea there is just, to get started with their operations, to grow the business. But after the 1 year, when they go to renew, CBP or USCIS really wants to see that they've grown the business. And this is shown with their employee headcount. This is shown with revenue. This is shown with the growth of their overall operations. So it's not a long period of time to do that. So it's really important when the applicant is initially filing their new office application. Upon approval, they're immediately ready to begin and grow their operations in order to be ready when it comes to that year mark to renew their visa. And then for those that are not establishing a new office and there's already an office here, typically their validity period, it depends, can be 2 or 3 year period.
Excellent.
With the ability to renew.
Yeah. And do you have so talking to existing companies or, maybe organizations with operations abroad that are considering opening a new office in the US, they've looked into the L1, they're considering it. Do you have any tips or key considerations to keep in mind about the process and about the application?
Yeah, the main thing being that, if they're looking to set up a new office, they just have to be prepared that within that year's time, they have to show sufficient growth in the business to be eligible to renew. It is a strict, hard 1 year time frame to do that. So if they're not ready to begin operations immediately and grow immediately upon the initial L1 approval, maybe they should hold off on applying until they're able to do so.
Yeah, and that's one of the major downsides of the L1 new office. It's a great category in general. It's going to accomplish your goals of setting up a new office in the US. They just don't give you a lot of time, a big runway to really ramp up your US entity. Now, like Ruth was saying, if your operations don't grow significantly within that first year of operation, it can be very challenging to renew your L1 at the 1 year mark. However, that doesn't mean that you can't renew it after the fact if you've set up the business, put the business in a position to continue its growth while you remain abroad. So logistically, it can be a little tricky if you're not able to, experience that immediate growth. But if you do set it up operationally and you get a good infrastructure in place and you have the right people in place to grow the company while you're abroad, you're not going to be precluded from applying for another L1 after the fact. You just might not be able to do it immediately at that 1 year mark. You might have to go back to Canada or whichever country you reside in and wait for the business to get to the point where you're in a position to apply for a regular L1. Some other considerations with the L1 is that the category itself is capped. Ruth, can you tell us a little bit about the cap for the L1A and the L1B and maybe, some exceptions to this cap for our friends to the north in Canada?
Yes. So for the L1A, for those that are applying in a managerial or executive capacity, the maximum period that you can have this visa, if you're relocating or spending a majority of your time in the US within a year period, is 7 years. And then for those applying under the L1B, which is a specialized knowledge position, the maximum period is 5 years. So as I mentioned, or as Zach mentioned, there is an exception, and that is for those who qualify as intermittent border crossers. So those who spend less than half of the year in the US each year, they have the ability to indefinitely renew their L1 as long as each time that they're applying, they still meet all the requirements to do so. So typically to show this, when we're applying for a renewal as an intermittent border crosser, we include the applicant's I-94 travel history within the past 3 years, and we create a detailed travel log which evidences the number of years that they've spent each year in the US for the past 3 years, to show that, you know, they qualify in this capacity and they can continue to renew beyond that maximum period.
And what about family members of L1 visa holders? Are they eligible for any sort of status?
Yes, yeah. So one of the benefits of the L is that your dependents, your spouse, children do qualify for L2 status. And an even greater benefit is that your spouse can have immediate work authorization with the L2. This is not tied to any particular employer, so they can work with anybody. There's no restrictions there. And then the children may attend school. Another benefit of the L overall is that it is a dual intent visa, meaning not only that does it give you the ability to live and work in the States, it also allows you to have the ability to work towards permanent residency. And one of those routes is through the EB1C. We usually refer to this as the L on steroids. It's a lot more document heavy application, but one benefit of it is that it completely bypasses the lengthy perm labor certification process. So it's a really great option for those that qualify. So there's that. You have the dual intent and the ability to sponsor your dependents.
Yeah, it is a nice benefit for L1 visa holders. It doesn't necessarily mean that you can't apply for a green card from other non-immigrant categories like the next category we're going to discuss, the E2. It's just a more streamlined and efficient pathway to permanent residency in the US. Now, speaking of the E2, let's dive into that category. The E2 is known as the Treaty Investor Visa. And similar to the L1, it can be utilized to establish a new office in the United States. There are also other ways to utilize the E2. You could have existing operations in the US that you invested in 20, 30 years ago. If you can document that investment and meet the other baseline requirements, the E2 can be a pathway to transfer key personnel from an office abroad to the office in the United States. Now, to dive into the requirements, there's a few major key requirements for an E2 visa. Number one, you have to have a legal business entity in the United States. The actual structure, the legal structure of the business, there's a lot of flexibility in how you set up and structure the entity. The only rules are that it can't be a nonprofit. It has to be a for-profit business that's providing goods or services for profit. It also can't be a sole proprietorship. And this is based on one of the other requirements, which we'll get to in a second, called the marginality requirement. The company can't be marginal. It has to provide enough income, provide services and goods to provide enough income for more than just the treaty investor and their family. And the overall spirit of the E2 visa is to benefit the United States. The government wants to attract foreign investment to the US to support local communities, to support local economies, and to hire US workers and create US jobs. So as long as you have aspirations to do that, or you're already doing that, the E2 could be a viable pathway. The next requirement is that the US entity has to be majority owned and controlled by Canadian citizens. This is pretty straightforward. You just have to trace ownership back to the individual shareholders of the US entity. Again, there's flexibility in the overall business structure. You can have a holding company in between the US entity and the ultimate shareholder or shareholders. You could have 100 holding companies in between the US entity and the ultimate shareholder. Now, 100 holding companies is going to be problematic because we have to document the relationship between each of those entities, and that's going to be a lot of work, but it's still doable. As long as the individual shareholders at the top are majority Canadian and they express and have control over the enterprise, you're going to satisfy that requirement.
Mm-hmm.
The next requirement, and perhaps the biggest requirement, it's in the name of the visa, is the investment requirement. So in order to qualify for an E2, you have to make a substantial investment in the U.S. entity. For new companies, for startups, it's based on the overhead cost of the company, what the actual startup expenses are. Now, in practice, there's really two things that a consular officer is looking for when they're reviewing these cases. Is the overall number that you've invested of a magnitude, is it significant enough to actually commit you to this enterprise? If you go and invest $5,000 into a U.S. entity, even if that's truly enough to begin active operations, it's not likely going to be deemed substantial because the government's not going to be convinced that that number in and of itself is significant enough to commit you to the enterprise. So baseline in practice, we recommend an investment, at a minimum of about 65 to 100,000. The closer you can get to 100,000 or above, the stronger your application is going to be. But it also depends on the nature of the business. And this is the second thing that officers look for. So your investment, based on your investment, the U.S. entity has to be operationally ready. So what that means is for a consulting company, your total investment, what's going to be deemed substantial, is naturally lower because you have lower overhead costs. It's not going to cost as much to get your business up and running. However, if you're a manufacturing company and you have, significant expenses in equipment and supplies and office space that is going to allow you to actually manufacture the products you're going to sell or distribute, your investment is naturally going to be higher. And even if you say go invest $1 million, but you still haven't bought any of the equipment you need to operate, it's not going to be deemed substantial, even though the number itself is significant because you're not operationally ready. So what the consulate wants to see for new companies is that the amount itself is significant and that based on the investment, you've created an operational infrastructure and the company is operationally ready to commence operations at the time of submission. Now, for existing companies, or if you're actually acquiring an existing business in the United States, the equation is much simpler. They look at the fair market value of the company, and then they look at the percentage stake that you're purchasing. If you go and, buy a U.S. company that's valued at 500,000 and you're, buying it outright at 100%, you're going to need to go and invest the full 500,000 or very close to it in order for the investment to be deemed substantial. Alternatively, if the company is valued at 500,000, you're buying 50%, you need to invest at least 50% of that capital. So for existing enterprises, for acquisitions, the equation's a little simpler, but it still requires thorough documentation. The substantial investment, this requirement is the crux of these applications. It's what we're going to focus on when submitting the cases, and it's truly what officers focus on when reviewing cases. Now, the last big requirement is marginality. And I touched on this earlier. Marginality is essentially the concept that the U.S. entity has to benefit the U.S. economy. It has to be significant enough that it's going to generate more than enough revenue for the investor and their family alone. And it has to have the present or future capacity to hire U.S. workers. That's really the key. To demonstrate this for new companies, we create a business plan. We outline your growth strategy. We outline your 5-year hiring and financial projections. And we include this with the application. Marginality it's definitely a component of the case. It's absolutely a requirement. But for new entities, the focus is more so on the investment and less so on marginality. Because a new company, it's understood that you're not going to be operating and generating millions in revenue and hiring 10, 20 people as at the day you submit the application. That's the purpose of the business plan. That's the future capacity to be a non-marginal entity. For existing companies, or for companies that are going to renew their E-status, marginality is a much more important aspect of the application. Because the consulate's going to want to see tax returns. They're going to want to see payroll records. They're going to want to see that you have that significant revenue, that you are hiring U.S. workers, and you're not a sole proprietor or a nonprofit or a marginal enterprise. So marginality, very important. We document it through a business plan for new companies and through tax returns and payroll records for existing entities. Now, the application process for the E2 is a little different than a lot of other categories, including the L1. So for E2 applications, these cases are primarily submitted to U.S. consulates and embassies abroad. For example, in Toronto, in Canada, an E2 application for a Canadian citizen is submitted directly to the U.S. consulate in Toronto. We submit documentation in advance, they review it, they then give us permission to schedule an interview. We go in, schedule the applicant for a visa interview, we do a lot of prep, we ensure they're ready, and then the individual goes for the in-person interview with the consulate. Now, this process will vary slightly based on your nationality because not every consular location in every country has the same submission or interview process. But overall, if you're applying for an E2 visa, you're going to have to go to the consulate or an embassy at some point to get the visa in your passport. The specific process may vary, but ultimately you need to get a visa.
Mhm.
Now, the E2, like I said, similar to the L1, it's going to enable you to create a new office. However, the E2, if you're eligible, does potentially offer more benefits than the L1 in some circumstances, primarily due to its longevity. The major benefit of an E2 visa is that typically it has more longevity and more flexibility in how long you use the visa compared to other categories like the L1, for example, that inherently has a cap.
Mhm.
Now, for most countries, Canada specifically, E2 visas are issued in 5-year increments. Again, just like the visa process, the validity period of a visa can vary based on your country of origin and the country you're applying in. But generally, these visas are issued in 4 to 5 year increments. In Canada, it's 5-year increments, and they're renewable indefinitely. Most of these visas are going to allow for unlimited entries during the validity period. So you have a ton of flexibility in how long you use the visa and how often you use the visa. And for new companies, it offers more benefits than the L1 because instead of a 1-year runway, you have a 5-year runway. So if you get an E2 visa based on setting up a new entity, the government's not going to go and look at your U.S. enterprise and the growth of your U.S. enterprise for 5 years. So you have a lot of time to really ramp up and grow operations. So for a lot of people, for a lot of companies, the E2 does offer more benefits than the L1. The downside is that the E2 is not available to everybody. The E2 is based on treaties with the United States. You have to be a national of a treaty country with the U.S. Some common countries include Canada, the United Kingdom, Japan, Spain, Netherlands, Switzerland. There's a whole list of these countries that qualify for E2 visas, but it's not every country. China, for example, India, for example, they're not eligible for E2 visas. So if they're interested, nationals from those countries or corporations from those countries, if you're interested in setting up a new U.S. office, you typically have to rely on that L1, and it's going to require some serious planning, some serious logistics to ensure that you're set up for success in the United States. Now, some other key considerations with the E2, primarily related to business expansion, is that upon approval of that initial E2 visa application, the U.S. entity is registered as an e-visa business. This registration then allows it to sponsor additional citizens of that nationality for employee visas. And it includes executives, managers, specialized knowledge employees, essential employees. The overall umbrella of eligible employees is much larger than who is eligible under the L1 category. So the E2 not only does it support business expansion by allowing you to set up a company or purchase an existing company, but it's going to allow you to transfer key personnel that possess the same nationality as the investor. So business expansion, it can support that. Other key considerations is that dependents, it has similar benefits to the L1. Spouses can apply for E2 dependent visas. Children can apply for E2 dependent visas. Spouses are granted work authorization. Children can attend school. So it facilitates both the investor and the employee, but also their family. So yeah, that's the E2 visa. Like we said earlier, business expansion in the U.S. can be very daunting, but from an immigration standpoint, there are some very good options. And if you're an organization or an individual that's interested in setting up a new U.S. entity, or say you have an existing company, you just need to transfer some key personnel, please feel free to contact us. We're very active on social media. We're on LinkedIn, we're on YouTube. You can visit our website. We put up content every single day about everything business immigration. So if there's anything you need, let us know. And I just want to thank everyone for joining us.